We're going to run through what disability discrimination is and what it means for schools in some detail. We're then going to look at the interplay of the Children and Families Act and the Equality Act, and we'll also touch on how to deal with parental complaints and what sort of considerations you need to take into account to preempt and try to avoid a disability discrimination claim being brought against the responsible body or the school. So in the first slide, we see we've set out very briefly the relevant legislation, which is in essence the Equality Act that we should all be familiar with, the Children and Families Act, which has a complex but significant relationship with the Equality Act, and you also have two sets of regulations which are important in the context of disability discrimination, and those are the Special Educational Needs Regulations 2014 and the Education Independent School Standards Regulations 2014, which apply to independent schools, including academies. In the next slides, I have set out some useful guidance that schools will want to take into account and read when considering their duties under the Equality Act. The first one is a document from the DfE that was published shortly after the Equality Act came into force, well, a few years after, I have to say, but it's quite a useful document. It gives you a whistle-stop tour of your duties. The second document is a much more substantive and, in my view, a really important document for all the schools to be very familiar with, and that is the Technical Guidance for Schools in England. It was updated in July 2024. It's updated reasonably frequently to bring it into line with case law and how we are interpreting the Equality Act, which is very much a live instrument. Now, the Technical Guidance for Schools in England contains all your answers in relation to equality, and it's a document that I recommend everyone in the schools to read at least once a year. It gives very many examples on how you ought to be supporting pupils with disabilities and other pupils with protected characteristics at school. Is extremely user-friendly and readable. The next document is the Public Sector Equality Duty Guidance for Schools. And I should say that both documents from the Equality and Human Rights Commission are non-statutory guidance documents. However, the Commission is tasked with overseeing the good implementation of the Equality Act, and therefore the guidance ought to be taken into account, albeit it's not statutory guidance. Then you have the SENCO Code of Practice, which sets out the duties of schools, all the schools, in relation to pupils with special educational needs, and 3 pieces of additional guidance that cut across your Equality Act duties and that you ought to be considering when dealing with a potential Equality Act claim, and indeed when supporting pupils in school overall. So that's the suspensions guidance, the supporting at school, pupils at school with medical needs, and the arranging education for children who cannot attend school because of health needs. Next slide, Taima, please. So the protected characteristics under the Equality Act are listed there. For the purposes of today's webinar, we're only going to be touching on disability. As you can see, there is a fairly large number of protected characteristics. Age and marriage partnership do not apply to pupils, but do apply to staff and parents and others. But for today's purposes, we will only be talking about disability and nothing else. Next slide, please. So what are your Equality Act obligations overall? Your Equality Act obligations apply throughout all aspects of a school life, and those include admissions. So they apply to prospective pupils, so not only your current pupils. They apply in the provision, all the provision of education that you make for those pupils, to all access to any benefits, facility of services that you provide within your school, to exclusions and any other detriment. The purpose of the any other detriment section within the Equality Act is to catch all those circumstances where pupils do require the anti-discrimination protection of the Equality Act, but may not be covered, may not be covered by specific sections, for example, on exclusions. As part of your Equality Act obligations, you have a duty to produce and implement a written accessibility plan, and that's at school level. The reasonable adjustments duty, which we will come to talk about a bit later, are intended to complement the accessibility planning duties and existing SEN duties under the Children and Families Act. Accessibility plans have to be published every 3 years and must contain a certain number of requirements. So, for example, increasing the extent to which disabled pupils can participate in your curriculum as you are delivering at the school, improving the physical environment of the school for the purpose of increasing the extent to which disabled pupils can take advantage of education, and improving the delivery to disabled pupils of information readily accessible to non-disabled pupils. The schools are not currently required under the Equality Act to make physical alterations to buildings or premises, but you do need to take reasonable steps to address any issues of accessibility. Now, the accessibility plans, if you have an accessibility plan that is defective and a disability discrimination claim is being brought against the responsible body or the proprietor, then it is possible that a tribunal may find that you're not doing enough to comply with your duties under the Equality Act. So, albeit it is a general duty, you must still very much make sure that your accessibility plans are up to date and measurable. Next slide, please. So we come then to the public sector equality duty, which applies to maintained state schools and academies insofar as they are funded by the Secretary of State. The public sector equality duty is a duty on public authorities, and that includes the schools, to consciously consider how their policies or decisions affect people who share protected characteristics. What this means is all aspects of a person's identity that are protected under the Equality Act, and parents and pupils may bring a legal challenge against the school through judicial review proceedings if they believe that the school has not complied with the public sector equality duties. Now, the public sector equality duty incorporates a duty to eliminate discrimination also on the grounds of disability and to advance equality of opportunity. So you always have to be keeping an eye on your public sector equality duties when considering your more precise duties under the Equality Act to disabled pupils. Taima, next slide, please. So what does it mean to have due regard to advancing equality of opportunity? This involves removing or minimizing the disadvantage to those with protected characteristics at your schools, including disabled pupils, taking steps to meet needs and encourage people who share relevant protected characteristics to participate in all aspects of school life. Schools must integrate the general equality duty within all of their operations, so they should do this rigorously, meaningfully, and should also keep a record of how they're doing this. It's not just paperwork. When making a decision or taking any action or developing a policy, for example, a school must always conscientiously consider what the implications would be for the quality of pupils with protected characteristics. We see disability discrimination claims being brought often on the basis that a school policy is placing a disabled pupil at a substantial disadvantage. And the tribunal in those cases will ask, what have you done to ensure that you have integrated your general equality duty into everything that you do, including the policy? So they will look at the minutes, for example, of the governing board when they came to review the decision and decide on the decision, and they will look at whether there was a specific reference to the public sector general equality duty to eliminate discrimination and equality considerations. That also, for example, applies to admissions, where you have to consider when settling your admission arrangements whether the changes that you're proposing would particularly disadvantage or significantly disadvantage a pupil with a protected characteristic. So then you have the having due regard to the need to foster good relations, and that involves tackling prejudice and promoting understanding. That's something that schools generally, I think, do well in the public sector. But again, just a reminder there that the promoting understanding also involves a promoting understanding of the needs of disabled pupils and how disabled pupils have a full right to be included in all aspects of education. Schools cannot delegate responsibility for carrying out their public sector equality duties to anyone else. And therefore, it's really important that all schools record how they have considered public sector equality duties, considerations, and everything that they do, and that they identify the policies that are most relevant to quality and keep them under regular view. Next slide, Taima. So a specific duty under the Equality Act it means that schools must publish information to demonstrate how it's compliant with its general duty. And one or more equality objectives it thinks it needs to achieve to meet the general duty. So it is measurable. It should be a smart target for all schools. Must be specific as well and relate to one or more of the requirements of the general duty. It is not enough, for example, to say that you are aiming in the next 3 years to improve school community relations. It has to be much more specific than that. You have to say how you're going to do it, set a timeline, key responsible people for ensuring oversight and implementation, etc. And it has to be measurable. That means that it needs to be directly or indirectly quantifiable, and good practice is to set out how progress will be measured. Next slide, Taima, please. So just a pause here before I pass on to Bradley in relation to disabled pupils and selective schools. As you know, and I think there are some grammar schools in attendance today, selective schools can refuse to admit disabled applicants who fail the admissions academic test, even if the failure is because of something arising from their disability. So if you have academic testing criteria, you are allowed as a selective school to say that if a disabled pupil does not meet that criteria, they will not be able to gain entry. However, the admission process for the test administration and everything that you do around testing and access to information about testing must in itself be accessible, and reasonable adjustments must be made to avoid placing that disabled pupil at a disadvantage when sitting the entrance examination or the qualifying test. Thank you very much. Bradley, over to you.
Thanks, Miriam, and good morning all. So going into disability discrimination specifically, in very simple terms, disability discrimination occurs where a pupil is treated less well or put at a disadvantage for a reason that relates to a disability. Now, you will often see references to disability in correspondence, and we thought the useful starting point would be to set out the legal definition, which can be found at Section 6 of the Equality Act. As it says on the slide, this is a physical or mental impairment which has a substantial and long-term adverse effect on the person's ability to carry out normal day-to-day activities. In this definition, substantial means more than minor or trivial, and for the disability to be considered long-term, it must have lasted or is likely to last or reoccur for 12 months or more. As you'll expect, this definition is very broad and will likely cover a wide range of illnesses and physical and mental conditions. There are also two other points to note. First, there's no requirement for a formal diagnosis to meet the legal definition of disability. And secondly, the law considers both actual and deemed knowledge. Actual knowledge is slightly more straightforward, whereas deemed knowledge occurs where a school should have reasonably been aware and expected to know of a disability based on the information available to it. Next slide, please. So the Equality Act sets out the different circumstances in which discrimination can occur, and the relevant sections for the purposes of today's webinar are set out on the slide. Firstly, looking at direct discrimination. Next slide, please, Tamar. So direct discrimination occurs where a pupil is treated less favourably than other pupils because of their protected characteristic, their perceived protected characteristic, or the PC or perceived PC of somebody they're associated with. For a finding of direct discrimination, a pupil needs to be able to demonstrate that without the protected characteristic, another pupil has been or would be treated more favourably. In very, I suppose, simple terms, the law doesn't allow for a pupil to be unfairly singled out or disadvantaged based on their disability. And as set out on the slide, there is no defence or ability to justify direct discrimination. Next slide, please. Indirect discrimination. So this is where a school will have a written or unwritten policy, criterion, or practice which applies generally to all pupils without regard to protected characteristics. Indirect discrimination could be found where the PCP puts or would put pupils sharing that protected characteristic at a particular disadvantage compared to those without it. Now, PCPs are found throughout school and all through school life. This could be formal policies, whether that be uniform policies or attendance rules, informal practices regarding how the school operates, decisions, actions, and arrangements, perhaps such as the organisation of school trips and criteria to access a benefit, service, or facility. You'll see the PCPs are very broad, and we thought they may assist to put this into context to provide two practical examples of where a finding of indirect discrimination may be found. Firstly, a school or academy could be planning an end-of-year reward trip, and the criteria to attend must be 100% attendance throughout the academic year. A pupil within that cohort may have a long-term medical condition and has missed a lot of school due to issues with regards to their health, and they're told they're unable to attend. The policy of requiring 100% attendance may put that student at a particular disadvantage, as in they were not able to attend as a result of their ill health. A second example could be the strict implementation of a school's behaviour policy. For example, zero tolerance on swearing. One particular cohort may have a pupil with severe Tourette's who continues to be sanctioned throughout the school year as a result of inappropriate language that is demonstrated throughout the school day. Again, this could be a potentially risky situation because the policy of a strict implementation of a behaviour policy puts that student with that disability at a particular disadvantage compared to the other students who don't have that medical condition. An important distinction for indirect discrimination as compared to direct discrimination is the ability to defend a policy, criterion, or practice as a proportionate means of achieving a legitimate aim, also known as objective justification. And we'll explore this further on the next slide, please, Tamar. So, looking at objective justification and proportionality, essentially, this means that both the reason for the rule or the practice is legitimate and that it could not be reasonably achieved in a different way which did not discriminate. This is a particularly high threshold to meet, particularly in the context of the wide nature of PCPs the schools have and the wide scope of disadvantage as set out at the start of this slide. Next slide, please, Tamar. Under Section 15 of the Equality Act, a school must not treat a disabled pupil unfavourably because of something that is a consequence of their disability, provided that the school cannot justify the unfavourable treatment as a proportionate means of achieving a legitimate aim. Again, we thought it may be useful to provide some practical examples of this, which you may experience in day-to-day school life. The first being not permitting a disabled pupil who may be on crutches outside of break time because it may take too long for them to get in and out of the school building. Um, this is likely to be found unlawful. And secondly, imposing a suspension for behaviour which could be linked to a pupil's disability. Again, this is a challenging situation. Next slide, please. Reasonable adjustments is always a sort of tricky topic and it's a complicated area, and unfortunately is very fact specific. As set out on the slide, a school is under a duty to make reasonable adjustments, and where a provision, criterion or practice puts disabled pupils at a substantial disadvantage compared with others, the school must take such steps as is reasonable to avoid that disadvantage. In addition, where not providing an auxiliary aid or service puts disabled pupils at a substantial disadvantage compared with others, school must take steps as reasonable to provide that auxiliary aid or service. Now, I briefly looked at the different types of PCPs a little while ago, and these same considerations apply to reasonable adjustments. Reasonable adjustments must be applied to all aspects of school activities and the decisions that it makes by both teachers and staff. This could include admissions, exclusions, access to school trips, decisions at school, help and support in school, and access to learning activities and materials. Some examples of changes to provision criteria and practice could be the adjustment to a uniform policy, which may allow a student with an allergy to wear clothing that's made of a different material, or amendments to standard common school practices, such as a set time for a lunch break, 20, 25 minutes, and there may be additional fact-specific challenges in the background which could make that particularly challenging for one or group of students. Looking separately at the provision of auxiliary aids, some common examples of this may be a BLS interpreter for students who's deaf, or the need to modify a trip or activity to include a hearing loop for a student who may be deaf too. Because this is all really fact specific, a common question that we often get asked is, how do you define reasonableness, and are there sort of parameters or terms you can consider this within? And Miriam will now talk to some factors that you can take into account.
Thank you. Before I fully move into this new slide, I just wanted to touch on the auxiliary aid and the meaning of auxiliary aid within the Act. So legal cases have referred to the Oxford Dictionary to look for some guidance as to what auxiliary means, and it has been determined in numerous cases that auxiliary aid for the purposes of the Equality Act means helpful, assisting, affording aid, rendering assistance, giving support or succor. So it is hugely wide how it is interpreted. And auxiliary aids, to emphasize, are things or persons who help. So it could be anything from hearing loops, as Bradley has mentioned, to adaptive keyboards, special software, but it could also be persons. I dealt with a very serious disability discrimination claim, which spanned over almost a week, where one of the arguments was that the mother of a pupil ought to have been considered an auxiliary aid in the context of selective mutism, where the pupil would only speak via the mother. And there was much discussion about that. So when you're considering or thinking whether something is an auxiliary aid, remember that it is a very, very wide definition. And if it helps assess or renders assistance, affords aid, etc., gives support, is likely to come within the definition of auxiliary aid under the Equality Act. Now, moving on then to the reasonable adjustments duty. The reasonable adjustments duty is not defined within the Equality Act. The Act does not say what is reasonable, and that is because it is very case specific, so that nobody is left out of the protection of the Act. It allows the lack of a definition allows for the flexibility for different sets of circumstances, so that what is reasonable in one set of circumstances may not be reasonable in another, and therefore you need to rethink again and go back to square one in relation to what may amount to a reasonable adjustment. Schools, claims brought against schools often are in relation to reasonable adjustments, more often than not are in relation to reasonable adjustments. And for example, one of the things that we do see is the school saying, well, this is a provision that we make for students with X condition. That's not enough. What schools need to do is satisfy themselves that the provision that they're making and the reasonable adjustments that they're making are suitable for the child in question, and not simply for all children with dyslexia, for example. The crux of the reasonable adjustments duty is not whether something is an auxiliary aid or whether it is an adjustment to a practice, but whether it is something that is reasonable for the school to have to do. And it's not possible for a school to justify a failure, as Bradley has said. The duty to make reasonable adjustments is not new. It was in the Disability Discrimination Act. There's the new element in relation to the auxiliary aid and services, but schools will have been aware for a few decades of what it means. Many of the adjustments that schools are making are in relation to auxiliary aid, but not all. Just a final point on the duty to make reasonable adjustments before I go over the various bullet points of that slide is that schools under this duty are required to take positive steps to ensure that disabled pupils can fully participate in education provided by the school. And those positive steps also include a duty for the steps to be anticipatory. So you need to be thinking in advance about what your disabled pupil community might require and what adjustments might need to be made. And this is regardless of whether or not the reasonable adjustments are actually reflected in an EHCP or in a individual SEN plan, etc. So you must consider those duties regardless of anything else that's happening in the background with SEN and EHCP provision. So looking now at the factors that the Commission tells us we ought to be considering when deciding whether something is a reasonable adjustment. I've cited them all there. This is not an exhaustive list, but is provided as an indication that all of those will more often than not be relevant factors when looking at what whether an adjustment is reasonable. Not one of these factors trumps any other, and they must not be considered in isolation. Must consider all of them together as part of the same bag, and then see where the balance lies in relation to reasonableness. So the first factor is the extent of the special educational needs provision that is being provided or met under Part 3 of the Children and Families Act. And that is considering what provision you're making, and does that provision minimize the disadvantage, or is there something that you need to do over and above the special education provision that you are already making? You can then look at the resources, sorry, I should say on the provision, the SEN provision, there is significant overlap between those pupils who are disabled and those who are who have SEN. Many disabled pupils will receive support through the SEN framework, but in some cases, the disadvantage may not be fully overcome via that SEN provision, and the school is required to top up with reasonable adjustments to make sure that the disadvantage is minimized or removed altogether. In relation to the school's resources and availability of financial and other assistance, So again, a huge amount of flexibility here. It is more likely, for example, to be reasonable for a school with substantial financial resources to make an adjustment with a significant cost than for a school with fewer resources. And when looking at resources, there is case law that tells us that you're not simply looking at the cost of that specific adjustment, but whether it is very large. For example, there may be an adjustment that costs £70,000. That on its face seems to be not reasonable. The tribunal says, no, you must not stop the analysis there. You must look at the coffers of the school. So is it reasonable in the context of the overall budget and the overall financial health of that particular school? So the analysis has to look at the much wider picture and to stop simply at looking at the very high cost of an adjustment. Now, I've covered the financial of other costs or making the adjustment, and I'll pause on that in a slide in a minute. The next point there is the effectiveness of the step in overcoming the substantial disadvantage. So schools need to think carefully about what adjustments can be made to avoid the disadvantage experienced by a disabled pupil. Even pupils with the same disability might need different adjustments to overcome the disadvantage, and it's important not to make any assumptions about a disabled pupil's needs, because this may lead the school to provide a completely ineffective adjustment, and that's why one of the obligations brought in by Section 20 of the Quality Act is to assess the effectiveness of the step in overcoming the adjustment. So just providing coloured overlays to a dyslexic pupil may work for another pupil, but may not work for the people that you're dealing with. And if the adjustment isn't effective for that pupil, then it's not, doesn't comply with the duty to make reasonable adjustments. It is, however, unlikely that an adjustment would be reasonable if it would derive very little benefit or marginal benefit in reducing the disadvantage experienced by the pupil, even if the pupil requests this. And again, you as expert educators will be able to assess whether an adjustment is capable of having a sufficient impact to reduce the disadvantage. And if it is marginal, then regardless of any parental request on it, you may be entitled to refuse it on the basis that is not reasonable, because it will not have the positive effect desired. There are other reasonable steps that school could take, and if when you put them all together, however small, that would have a substantial, that would have an impact on reducing the advantage, then those small steps must be taken, because when put together, they are effective in overcoming the substantial disadvantage. Now, in relation to the practicability of the adjustment, for example, if a pupil has a wheelchair who is unable to access the first floor, there is no lift at the school, you're not required to put one in. A reasonable adjustment would be, for example, to rearrange the timetable and the location of the classes so that all the classes are on the ground floor. However, taking that one step forward, if your labs are on the first floor and it's not possible to move an entire science lab to the ground floor, it may be reasonable for the student not to have the labs the same way that other students are accessing the science learning. However, that doesn't redeem you from your duties. You still need to consider what other adjustments you could make to enable the disabled pupil to access learning opportunities in relation to the science lab to those of their peers. The effect of the disability on the individual is quite important, and again goes back to the concept that no one disabled person is the same as the other, and we have to listen and understand what their needs are so that we can fully know whether an adjustment would be reasonable and what the effect on the disability would be of not making the adjustment. Health and safety requirements come into play as well. when looking at reasonable adjustments. So the Act does not override health and safety legislation. If making a particular adjustment would increase the risk to the health and safety of any person, then it's a relevant factor when deciding whether it is reasonable to make that adjustment. For example, this sometimes arises in relation to the installation of chairlifts in school stairs, and health and safety considerations there kick in. You would still need to consider whether the adjustment is reasonable and do your quality assessment under the Quality Act. Now, the need to maintain academic, musical, sporting and other standards is also something that you are allowed to consider when looking at this question. And it means that you're not prevented as a school from choosing, for example, your best footballers or singers or mathematicians, where a consideration of a standard is relevant. For example, where you're competing with other schools in a maths Olympiad. However, it should not be assumed that a consideration of standards will mean that a disabled pupil will be barred from an activity. You still need to consider whether the standards will be affected, and if so, how, and only then, when having looked at everything, would come to a decision that the disabled student may not participate in something that involves such standards. Now, the interests of other pupils and prospective pupils, this is a tricky one. This is one that we often get asked about, and there is always a balancing exercise in schools between the rights of disabled pupils and the rights of everyone else at the school and the rights of all of them jointly. Ordinarily, the interest of other pupils regarding the reasonable adjustments duty will be irrelevant, however. There are some limited circumstances in which the provision of a particular reasonable adjustment for a disabled pupil will disadvantage other pupils, but this is only relevant where the adjustment results in significant disadvantage for other pupils. So it again, very much case specific, and quite often the health and safety considerations tie in with the interest of other prospective pupils, but generally the interest of other pupils and prospective pupils is relevant when considering your duties under the Equality Act. So moving on now to the next slide, I just want to talk about charging for reasonable adjustments, which is prohibited under the Equality Act. That's section 20, subsection 7. It is unlawful for any school to charge a pupil for making reasonable adjustments in any circumstances, whatever the financial cost of the school and however the school is funded. However, the cost of an adjustment is one of the factors to be taken into account when considering whether or not the adjustment is reasonable. So I go back, and I don't need to move back to the previous slide, but this goes back to what I was talking about earlier, that resources and financial impact is only one of the considerations. But once you have concluded that the adjustment is reasonable, you must fund it, cannot charge parents for the adjustment. And that is because if a child is under a substantial disadvantage in comparison to non-disabled pupils, the duty to make reasonable adjustments applies, and the responsible body or proprietor or governing board must fund all reasonable adjustments. It cannot require in law the parents to pay for the adjustments or to contribute to the adjustments, even if the parents are willing to do so. Parents can volunteer to contribute to the adjustments, and that's a factor to be taken into account when deciding whether the adjustment is reasonable. But once you have decided that the adjustment is reasonable, you cannot require a payment or pass on the cost onto the parents. Next slide, please. So now talking about the disability discrimination claims, the next two slides. So these are claims brought by parents in the first year tribunal, the Special Educational Needs and Disability Chamber, the tribunal, and they're commonly known as SENCOs claims. This is the only way that parents can bring disability discrimination claims against all types of schools, other than special independent schools, but I'm not going to touch on that there. The claims are brought against the proprietor or the responsible body, and not against the head teacher or members of staff. Very often when a disability discrimination claim hits the in-tray of a school, they immediately call us. They say, what does this mean to me? Do I need a union representative? Is this against me personally? Are members of staff being named, etc.? Just to be absolutely clear, claims are brought against the proprietor, the responsible body, and not against individual members of staff at the school, albeit obviously they would have had they would have dealt with the situation in a way that perhaps wasn't compliant with the discrimination claim, but the respondent to the claim is the proprietor or the responsible body. Parents, if they wish to bring a claim against an act or an omission by a school where they say that their disabled pupil has been disadvantaged, they must do so within 6 months of the discrimination happening. But sometimes you can't pin that date because it's an ongoing act that has been taking place for some months, and therefore when we come to look at a discrimination claim to determine whether the claim is has been filed in time, then we also consider whether there are ongoing acts, or is it a single act, for example, a permanent exclusion. Now, disability discrimination claims are legally highly complex claims for which, in my view, legal assistance is required. All of you in your schools will be covered by legal insurance, and legal insurance does cover normally the full cost of disability discrimination claims. Moving on to the next slide. So, SENCOs hearings. SENCOs hearings, when a parent brings a disability discrimination claim, there are full-day hearings if it's not a very complex claim. I've done cases up to 5 days long, but generally speaking, they're a single full-day hearing. They're conducted remotely. The attendance of witnesses from the school will be required, and so will be witness statements and bundles of evidence, which have to be compiled well in advance of the final hearing. There will be interim hearings before the final hearing. At the hearing, you will have one judge and generally 2 lay members considering the claim, and it is an adversarial process. So both sides will be setting out what they say about it and their defenses. If you are the responsible body for a school, etc., it will generally involve the head teacher giving evidence, likely the SENCO, and most likely than not the class teacher. They are quite stressful hearings for staff, but with good preparation from your legal team, you should be able to deal with them quite effectively and minimize the stress. Many disability discrimination claims settle prior to them coming to a full hearing, and this is because it is often the case that schools have failed in one or more respects, and they take a pragmatic decision to settle the claim, or they take a decision that they would like to acknowledge that there had been disability discrimination. So not all claims get to a hearing. There will be extensive witness evidence from the staff of the school and also from parents, their experts. If they're bringing experts, and they're entitled to do so. The outcome of a tribunal hearing in relation to a disability discrimination claim is a very long written decision, normally is between 20 and 30 pages, can be longer, setting out the findings of facts, so what the tribunal say happened or didn't happen, and whether what happened amounted to disability discrimination in all of some of the claims, so they can find in favor of the parents in one or more of the claims or in none of the claims. The typical remedies that the tribunal can order once they have made a decision that there has been disability discrimination include reinstatement in the event of a permanent exclusion, an apology letter drafted by the governing body or proprietor, and again, that no remedies will be granted against members of staff. All the remedies are ordered against the responsible body or proprietor. Staff training, and a note there that the tribunal do not have powers to award financial compensation in relation to disability discrimination claims where the claim succeeds. Parents are at liberty to make the decision public, and in all my years of practice, I've only had one case where we successfully argued that there should be a non-disclosure order placed on the parent, and that was solely because the disclosure was thought to put the a pupil at risk of a mental health breakdown, and there was some evidence of that. But other than very, very exceptional cases, and that was determined via a full day hearing just to talk about the issue of disclosure. Other than that, once the parents have the decision of the tribunal, they can disseminate as they see fit. And parents will often send the decision to Ofsted and the local authority, and sometimes to their member of parliament. Now, Ofsted is generally not particularly concerned if they are sent a disability discrimination claim by a school, unless obviously it becomes a pattern and they have a portfolio of disability discrimination claims having been upheld against a particular school. However, Ofsted in the next visit will want to know what you have done to remedy the failings that were found to exist at the school. So it's important that if you're ever involved in a disability discrimination claim, you keep that has been upheld against you, you keep a good record of how you have remedied the shortcomings that were found to exist. And the same with the local authority. Local authorities will generally not go back to schools on anything related to senders appeals in the context of disability discrimination. Next slide, please. So I'm very conscious of time. I've just realized how late it is, but I'm going to touch briefly on the Equality Act and the Children and Family Act duties. Taima, next slide, please. So just some points to remember: the Equality Act duties and the Children and Families Act duties coexist. Children with SEN and with an EHCP are very likely to fall within the meaning of the Equality Act as a disabled pupil. There are two parallel legal frameworks. You must keep an eye on both. If an EHCP is defective, however, the reasonable adjustment duty still applies. And conversely, if the EHCP provision removes substantial disadvantage, then reasonable adjustments duty is satisfied. So the fact that an EHCP is effective does not redeem you from your duties under the Equality Act. You still have to make those reasonable adjustments. Next slide, Taima, please. So when looking at whether you are doing everything that you ought to be doing to avoid obviously not supporting the pupil as you should, and also a disability discrimination claim in the context of a CN, you will be looking at whether there are any unmet needs, are there any additional assessments that are required, will be reviewing your current support and any changes needed to that support. You will, I normally advise my schools to rate Section F to conduct the really careful analysis of what provision has been made and what provision has not been made, and where you may be falling short of your duties under the Equality Act or the CFA or both. You will contact the local authority at an earlier stage to request an emergency annual review. The emergency annual review meetings are your best tool to ensure that the EHCP is reflective of all the reasonable adjustments needed, so that you don't have to bridge the gap between a defective EHCP and your and you will ensure that there are good communications between your senior leadership team, the SENCO and the class staff, and in the case of LAC or children with a social worker, will involve the virtual school heads and the social worker and invite them to meetings and any hearings that may happen if they do in the context of disability discrimination. Next slide, please. So I think for the sake of brevity, I am not going to stop on the next two slides, and I'm going to hand over the floor to Bradley. We just inserted a couple of slides on case law on disability discrimination. You're welcome to read those. Bradley, over to you.
Thanks, Miriam. So moving on to the next slide, please, Taima. Two common areas of dispute we see are the use of sanctions and the failure to make reasonable adjustments. Now, looking at use of sanctions first, as set out on the slide, sanctions can be applied to disabled students. However, extra caution must be taken and proportionality really is key. Schools will be asked to demonstrate and evidence that it was doing everything that it could do before an incident took place and during the decision-making process, demonstrating that proportionality to impose this sanction and take the action that it has taken. Um, as with all of these matters, this is very broad and fact-specific, but there are a number of, I suppose, general factors you can take into account. Firstly, making sure that all relevant supports in place, considering risk assessments and whether there's any issues with regards to these, and asking other professionals for their input and support. There's also reference to failure to make reasonable adjustments, and we covered that off slightly earlier, but it's just to re-emphasise and reiterate the point that schools really need to carefully consider what reasonable adjustments should be made to support students in schools. Next slide, please. Um, I suppose the caveat to this slide before I go into any real detail is to acknowledge that it's very easy for us to sit with a PowerPoint deck and say address concerns at an early stage, but we do know from working with many schools and academies that lots of good work is done to build and develop relationships with parents, and this can be difficult at times. And the real message we're aiming to get across is to challenge your own position. So where you can, take a step back and see what else could be done to improve tricky situations, ideally at an early stage. What are parents really seeking and how achievable is this in practice? How is the school's approach being communicated to the parents? Is it sufficiently clear? Are there any trends or themes, whether at pupil, cohort, or even school academy level? And is there anything that can be done to improve or change areas of concern? Separately, could input from other professionals assist in resolving matters? Getting the relevant people involved at the earliest opportunity can have a meaningful impact in addressing concerns and, more broadly, perhaps manage wider expectations in light of all the pressures that schools and academies are under. It won't always be possible to effectively manage concerns, but we're hopeful that taking steps early will assist in the long term with the wider school and parent relationship. And the final bullet point on that slide is a really key point, maintaining detailed and accurate records. If concerns proceed, whether that be complaints or claims, written school records really do become fundamental in understanding the school's approach and analysis. And they can really assist in addressing minor points which may be discussed some months or some years even later down the line. So the key message there is please keep good records. Next slide, please. Permanent exclusion is a frequent area of challenge, and the purpose of this slide really is to reiterate the nuclear status of the sanction. This sanction should be limited to the more serious circumstances, and where pupils have disabilities, extra caution must be taken. Should a claim proceed to the first-year tribunal, it will be expected that schools are able to demonstrate that every possible alternative has been considered before permanent exclusion, and schools will be asked to evidence that decision-making process and their analysis. Please always reread and consult the statutory guidance to ensure your approach is correct and all relevant considerations have been made. And particularly where these decisions are made with disabled pupils, seek input from others. This may be a conversation with parents pre-decision, a conversation with other professionals who have day-to-day involvement with this child, or even separately, maybe utilising the Trust's legal retainer scheme to have a really high-level summary conversation, considering the legal position based on the specific circumstances at the time at that particular school with that particular pupil. The next slide, please. And sorry, one more. Sorry, Taylor. This is a wash-up slide, really, just aiming to cover the more practical points that we've addressed today. Whilst you're in the middle of managing a difficult situation and managing lots of issues and considerations, there's lots of moving parts. It can be really difficult and tricky to keep on top of everything. Just please remember to reach out for support and seek input from others who may be able to assist with a way forward. And where possible, please really aim to objectively challenge your decision whilst ensuring that accurate records are retained and kept throughout. Next slide, please. So this slide is really aimed just to give some examples of how VWE can assist schools and academies. There's lots of different ways we're able to input and support. Please sign up to our free webinar, such as today. We cover lots of different topics which may be of use. There's a free schools law brief, and we also have a legal services retainer. There's toolkits, there's template policies. There's lots that we'd really be pleased to work with you on and consider how best we can support you at both school and trust level. Miriam, I don't know if there's anything you wanted to add there.
Thank you, Bradley. Yes, I just wanted to add that I've been trying to answer as many questions that have been asked in the chat facility, in the Q&A facility. But if any of you have any pressing matters or questions, then more than welcome to email us. Details are in the last slide of the slides. You will get a copy of the recording and the slides for your own reference, and feel free to share that with colleagues at your schools or trust. Thank you very much for coming and for being such a wonderful audience.